Hi everyone, my name is Charis Tan. I am a partner at Peter & Kim in Singapore, and I've specialized in international arbitration my entire career. I focus on three areas. One is international commercial arbitration, investor-state arbitration, and state-to-state disputes. Primarily, I act as counsel for either large corporates or states in disputes. Otherwise, I also sit as an arbitrator, both in commercial arbitrations and state-to-state disputes.
Hi everyone, my name is Lawrence Boo. I'm the head of the Arbitration Chambers. It's a private set of arbitrators who do mediation and arbitration. I've been involved in this area for quite a long time. I used to head the Singapore International Arbitration Center as CEO and subsequent deputy chairman. I sit in international cases on both commercial and international arbitration. I'm very pleased to be involved in this program. Thank you.
Alright, so ISDS really requires a basis of jurisdiction in a state-to-state investment treaty. It can be a bilateral investment treaty, that's the most common, multilateral investment treaty. Sometimes FTAs, free trade agreements, also have investment chapters. Now, how it works is that first you have the home state, and it enters into an investment treaty with the host state. When I say home state, I mean the state that an investor is from. So for example, if you think, let me give you an example, right? Luke Skywalker is a national of a home state, and he then decides to invest money and sets up a factory manufacturing lightsabers in the host state. What the investment treaty allows Luke Skywalker to then do is that instead of the usual requirement for a direct contract between him and any other party for basis of an arbitration, he can directly bring an arbitration against the host state. So wherever his factory is situated, let's say the government expropriates it, he can bring a claim directly against the country.
To be clear, I think what Charis says is exactly what a lot of people may not understand. Bilateral investment treaty or claims against states arise not out of a contractual arrangement, it arises out of a treaty, an agreement entered between two governments or two states for the benefit of investors. Basically, it requires a party who wants to invoke arbitration or claim against a home state to be firstly an investor, and secondly, he must have made an investment. What is an investor? And what is an investment? Of course, is one of the threshold issues that every arbitral tribunal will have to decide. So anyone who wants to commence a claim thinking that they got a claim against a country because it's unhappy with them, they must make sure they are an investor and they have an investment. So those are one of the basic building blocks to start off an arbitration against a host state. There could also be some investor-state disputes that could also be contractual. So, for example, a state that commences or invites a particular foreign party to build, say, their airport or their road system, and they have a direct contract with them. Sometimes in those contracts, they do also build in certain investor-state protection. So those are more commercial or contractual rather than what we call BIT or truly investment dispute.
The thing that mediation allows and negotiation allows is that it allows for flexibility of solutions. When you require that an arbitral tribunal makes a final decision, the thing is that the arbitral tribunal can only look at what it has jurisdiction over, can only look at the exact claims that are being put forward and then reach a final decision. But with mediation, because investors are much more flexible than just saying I need to have one particular form of solution, you might well have a state saying, all right, I can't give you this investment, sorry, I need to take that away, but I'll give you a different opportunity. And an investor could well say, yeah, sure, I'll accept that because I can make money in any way, and it doesn't necessarily have to be this investment in a sense that has been lost.
Absolutely. Every treaty, as far as I'm aware of, do have what they call a consultation period or cooling off period, like you said, and which parties who want to make a claim against the state will always have to serve a notice of intention to claim and given a certain period, 3 months, 6 months, 9 months, in fact one that was a year, which you have to engage each other in consultation or negotiation. The whole idea is to hope that they can settle. But of course, from my personal practice view, I've not seen any because I'm at the tail end of things. They have failed in their negotiations and consultation or mediation, which I think is quite rare mediation. I hope that there will be more before they come to arbitration. So I'm at the tail end, so I don't really see the consultation or negotiation bit. But having said that, there were 1 or 2 cases in which they actually settled, following the commencement of proceedings. So which is good, which shows that behind the scenes sometimes people do talk, and they should be encouraged to do so. It's always good to have a deal rather than any deal is a good deal. Okay.
I would say that in practice, most of the time, in fact, the starting of an ISDS case is a means to an end, whether it really must require an award or quite often if it can be settled in between, then that's an even better outcome for both parties.
There's a lot of positive in settling early because investors are always long-term people. They are not like a commercial transaction or once off. They're there for 10, 15, 20 years. They build a road or an airport or a factory. They intend it to be an ongoing concern for a number of years.
Yeah.
So they should be slow to want to spoil their relationship, spoil their business in the country. And a lot of brand building takes effort. So by building a brand, a name in the country, you really don't want to let it burst in the air because you make a claim against the whole state. So there should be a lot of incentive for parties to seek negotiation and consultation, and in fact, if that fails, mediation to ensure that it will not just burn up because there's a dispute with the whole state. But of course, that's easier said than done. In some cases, whole state do misbehave, and that in which case they really have to face what the consequences of that the default that they've created.
The key for states is that there's many politics involved sometimes, and certain investments may be very politically sensitive. So sometimes the states, whether because of change of the governors in charge or due to certain internal considerations, they just have no choice but to change the direction on a particular investment. And that's when if they might be able to seek a different solution as opposed to being welded to a particular contract that they had awarded previously. That's what they seek as well.
Yeah.
Okay, so in terms of criticisms of the current ISDS setup, there's plenty, and I could talk for 5 days on this. But really, it comes down to a couple of things. One is proceedings are sometimes too long. Number 2, proceedings are too expensive. Number 3, a lot of times states don't like the outcome because unfortunately ISDS is an area where states are only the respondents, right? And they have been shocked by some large awards against them over the years. And so states have quite vocally objected to how they find themselves on the receiving end of these claims. Now, the reality is that sometime in the 90s, when these BITs, a lot of these BITs were being signed, a lot of these investment treaties were being proliferated, people were excited, or rather states were excited at the prospect of bringing in more FDI, more foreign direct investment. But a lot of them, when they signed on the dotted line, they didn't quite know what they were signing up to. And so that's the issue, and that's why some states have found themselves surprised by the awards against them. Now, where does this bring us to? There's been a lot of questions as to whether or not this setup, this global setup for the resolution of investment disputes, whether it really serves the purposes of states that well, whether or not it really effectively brings in foreign direct investment. But the reality is that investors love it, right? Because they see it as a form of protection for their investment. more and more investors are not just looking at the actual cases and actually bringing a case. More and more of them on the ground are looking at how they structure their investments even before they put in the money, before they put in their first dollar. So it is something right now that we live with. Now, where does mediation come into all of this? Right? As I said, the reality is that proceedings nowadays are quite often known to be long, expensive, not necessarily leading to a satisfactory outcome. So particularly for states and investors want a shortcut. That's practical, and that is, it makes sense, it's logical, right? Any investor will not want to have to sink more money into an investment which it deems might have gone down the drain. It would like to have a good solution, a solution it wants, a solution it likes, and so an amicable agreement is much more preferable. And if it can be reached early, then that's also more effective from a dispute resolution point of view, right? As I said, and this goes back to a point I said earlier, a lot of investors seek negotiations, seek settlement before they even file the notice of dispute, right? After they file the notice of dispute, the other stage at which you see a lot of settlements is when they are filing the request for arbitration around that time, right? Because that's when you really effectively start the proceedings. And so sometimes they try to reach a settlement before proceedings officially start. Then you have various milestones along the way during proceedings, but quite often the next sort of bulk of time, of period of settlement is early on in the proceedings, before either party has spent too much money in terms of legal costs or time or effort, right? Then if it drags on longer, then the next bulk of settlement tends to be around the time when you have a merits hearing. So in the lead up to a merits hearing, people start to feel a little bit more nervous. They feel like this has all come together. They have a clearer sense of the strengths of their cases. And that time, either just before or right after a merits hearing, that's when you will see quite a lot of settlements.
Both sides have a role to play. And don't forget also that international bilateral investment treaties and international investment law is a Western construct. Now I'm speaking like a nation. And that there were the days, these rules and laws were formulated by investor countries, investor states, not the whole state. So they drafted all these processes for the benefit of the investor. And as she said, very rightly, that all claims in exit claims or all investors are against the whole state. Whole state is always the respondent. So they naturally feel the pressure. And a lot of those were experienced by Asian or developing states. But there's a change, in the world economic climate. The developing states, some of them have now become developed states. And they will be the ones who will be making claims. I think the rules of investment arbitration should not change, because it's time for the developed countries, the earlier developing countries, to now be protected when they are now investing in the formerly developed states. So in my view, I think some of the grouses are valid, some of the grouses are very looked upon at a certain angle. Yeah? And it's not a fair way to judge the system, because the economic landscape in the world has changed. You find that claimants now are not just Western countries. Claimants now have moved to formerly developing countries to almost developed countries. They have now no longer third world countries in a sense. Yeah. So I mean Pedro Branca, for example, so long as you don't impinge on the sovereignty, I can't imagine anything else that cannot be mediated.
Go ahead, finish first.
Unless, of course, we're talking of bribery, corruption, those very sensitive areas which nobody will admit to it. It might be a bit tougher. But I think everything should be mediable. Yes.
Let me be bold
Yes.
and say that I think it almost always comes down to either international politics or domestic politics, right? When something gets so sensitive for state, so sovereignty I would put under the rubric of international politics, because when your people feel so strongly about a particular issue, or a state feels strongly about a particular issue, and it believes that these are my strict legal rights, right? It will just not be willing to go to mediation. I mean, we can think even in this region of not just territorial sovereignty disputes, but quite a number multilateral, very difficult issues, which I think states just cannot budge on, basically. And then, in terms of domestic politics, unfortunately, I think sometimes it goes back to how certain investments, for example, a particular port can be very sensitive, or another government's military presence on your grounds. It might be so sensitive that the two parties are just not willing, or just cannot have leeway to mediate it, to negotiate a solution. Because unless you have a binding resolution, a binding decision by a tribunal somewhere, the state cannot move in any direction, right? I have seen cases where states have told me that confidentially, we need there to be a decision. Even if we accept that the other side has a better case, that the other side will win, we need the decision to be handed down before we can comply with it, because we cannot otherwise explain it to our populace.
No, I agree with Charis. All those examples you cited are all difficult cases to go to mediation. But I will classify them as not capable of being mediated. Those are because of their local domestic politics that prevent them from being even able to suggest mediation. For that matter, if any country, most civil servants or most government politicians will not want to admit, by agreeing to go to mediation, to some degree admits that they might be wrong, or there are some degree of wrongness on their part. So it might be difficult to move them away from that mindset. And rightly, a lot of government servants and parties will tell you, state parties will tell you that no, it's not possible, because this is our policy, this is the stand we take. We can't answer to our electorate if we take a certain position. But those are difficult problems. Yeah. But I don't think subject matter-wise they cannot be mediated. That's why I take the position that everything can be mediated, whether or not they can cope with the pressures that prevent them from doing so. Of course, historically, the mediation is not even mentioned in many treaties, although sometimes they say consultation and conciliation. And I think it's time for investors and states in the BIT to relook the old documents and come up with new formats, encouraging people to at least think about mediation. And I was excited just now when I looked at and checked out what's the latest in Singapore, and came the news that Singapore and Indonesia's BIT, which was signed in 2019, has just come into force. And one of the provisions there is for mediation. Very nice mediation clause there, which is very encouraging. They don't say that you must go to mediation. They are saying encouraged to request mediation, and that the other party is encouraged to respond positively to a mediation request, and they were given certain timelines without strict rules being stipulated as to when you must do this, when you must do that. Sometimes in mediation, maybe certain provisions are too cast in a formalistic way that becomes a barrier, so that people go through mediation because they have to go through.
Exactly.
They are not convinced, they are forced to go through.
Yeah.
And that will not work. I mean, just based on ICSID's data itself, I also checked the ICSID's data. Based on their data, only 14% that went for conciliation succeeded in mediation, which is sad, isn't it? Yeah, which should not be the case. If parties want, you put it in the treaty and encourage people to go, they will be prompted to go. It gives them a window, an opportunity that a door is open, we can do it. And I may even suggest that even if the matter goes for arbitration, as a procedural order, number one, we can always provide for a window for the parties to consider mediation as part of the arbitration process. So we can med up, We reintroduce that in the investment treaty dispute resolution process. I think it's going to work on this.
The point that Prof Boo is making is a very important one. It's a very fine line between saying that you must go to mediation versus just saying this is provided for, please think about it. You are encouraged to consider it, right? And the very core of mediation, the very core of the idea is that it has to be an agreeable position. It has to be something that both parties are willing to go to and are willing to agree upon. So it doesn't quite work if you say you are forced to go to mediation, right? I think that's the key. I mean, in terms of investment treaties nowadays, the trend is very much towards putting in some form of mediation annex. Some are more elaborate than others. Some is just a clause to say, please consider mediation. Some actually have entire, like the EU Singapore FTA, which has an entire chapter 15, I think it is, on mediation and what the procedure should be, how you select a mediator, what are the rules, how do you apply it, how do you go about it, which is quite extensive. But I think the key goes back to the same point, that it should be something that is not inserted to make the entire dispute resolution clause more complicated. You don't want to make it into a multi-tiered dispute resolution clause. I think that then in fact makes it even more complicated, makes it more expensive, because then people are fighting over jurisdiction,
Correct.
over admissibility. So then that doesn't really work. But if you say, well, this is not binding, but this is somewhere in the mix, so please make sure that you apply your mind to it. I think that's a great way, and it fits perfectly with the entire idea of mediation.
When you have a clause or a provision in the BIT that talks about mediation, and one party initiates it, it looks bad on the other side not to respond. So it is actually a very wise way of doing it, rather than to put in as a rule that you must, within how many days, file a notice to mediate. That kind of thing sort of make people obliged to do certain things, and it's not something that work very well based on just the exit data. So I think what we have done in the Singapore-Indonesia BIT, I'm quite excited about it. I think that hopefully there will be no disputes with Indonesia, no claims in Indonesia or Indonesian claims in Singapore, and let's see how it works. I think it's a good one. I read through it, I thought it was very good.
So this is a very real answer, because this is a situation that we've been in multiple times. I'll say use both. So first, you go in hard, you go in strong, you go in fierce, right? You go in with the notice of intent, you go in with the notice of arbitration, hit them hard, and you then hope that the state sort of wakes up, right? Because unfortunately, the state is a huge machinery. It takes time for even the notice of intent or the notice of arbitration to go to the right level. Once it hits the right level and people are taking note of it, then that's when you say, okay, I've filed this, if you don't want it to go further, let's sit down and talk. And in a very real sense, we then sometimes enter into protocols between two parties to say, all right, we are looking at mediation, negotiation. What are the boundaries? What are the four corners of what this process might look like? Confidentiality, you will not use it to the prejudice of your position, your legal position, etc. What level of representation? This is a very, very real thing when it involves states. What level of representation is going to be there at the meeting, at the mediated settlement or session, right? The key is that the person who's there representing the state must have the power and the authority to be convinced and to enter into a settlement with the investor. So I would say it's very, it's absolutely crucial to think about all these different tools as a practitioner, not just as counsel. Once I file a request for arbitration, that means that the final step that I'm going to reach is definitely the award. No, in fact, I want to find the best possible solution to successfully resolve the issue for my client. And what does successful resolution entail? Very often it means a mediated settlement or negotiated settlement, something that's amicably reached.